G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and you're listening and watching the Australian Family and Fertility Law podcast. This is only a short video about events last week. Last Wednesday, US time, the US Supreme Court heard the challenge to President Trump's executive order on birthright citizenship. That executive order says that no one is entitled to US citizenship by virtue of being born in the United States unless they have an American parent who is either their mother or their father and is genetically their mother or their father. That case impacts on many Australian intended parents undertaking surrogacy in the United States, as well as intended parents through surrogacy in many other countries going to the US. In any event, the matter was heard last Wednesday before the 9 justices of the Supreme Court. President Trump turned up for a couple of hours, presumably to be there in support of the government case, because this is a matter near and dear to him, and no doubt eyeballed all the judges who haven't agreed with him he has criticised recently. But it seems it didn't go well. I've had the benefit of reading the transcript, and the transcript clearly shows that it is most unlikely, at least in my view, that the birthright citizenship executive order is going to survive. The Constitution of the United States is quite clear. The 14th Amendment, which was added into after the Civil War to recognise, amongst other things, the citizenship rights of slaves and their children, that this in effect means that, as I read it at least, if someone is born in the United States because their parents happen to be there, provided that part of the United States is not under occupation and the parent is not a foreign diplomat, then the child should be entitled to American citizenship. In my view, it is highly unlikely, in light of the sceptical questions of counsel in the case, that the US Supreme Court will uphold the executive order. But we wait. It's expected that the judgment will be delivered by June, which is remarkably quick, at least by Australian standards. But it was certainly argued out for hours, and counsel were peppered with many questions by the justices. So let's wait and see. But at this stage, I am optimistic that the US Supreme Court will follow tradition, follow its previous precedent from 130 years ago, and for children born to Australian intended parents via surrogacy in the United States, recognise those children as US citizens. Thank you for watching and listening. I'm Stephen Page, I should say, from Page Provan Family and Fertility Lawyers, and this is the Australian Family and Fertility Law Podcast.